Okay, good evening, everyone, and good afternoon and good morning. We are lucky today to have people dialing into this call from all over the world. We hope this call on the legal issues arising from the 2020 election is somewhat less dramatic than a call with Jeffrey Toobin, but we hope perhaps more informative. My name is Jonathan Turner. I am a board member at the Institute for Constitutional Advocacy and Protection at Georgetown Law. Let me introduce to you today two key members of the team from ICAP, Josh Geltzer and Mary McCord. By way of quick background, I know many of you will know Josh, but he is the executive director at ICAP. He was formerly legal advisor to the National Security Council, counsel to the Attorney General of the National Security Council on behalf of the Department of Justice. He clerked for Supreme Court Associate Justice Stephen Breyer, attended Yale Law School and was editor-in-chief of the Yale Law Journal. Mary is the legal director of ICAP. She is a visiting professor at Georgetown Law. She is formerly an acting assistant attorney general for national security at the Department of Justice, an assistant U.S. attorney in the U.S. Attorney's Office in the District of Columbia, and the deputy chief in the appellate division on the Circuit Court of Appeals in D.C. For those of you who are not familiar with ICAP, it was founded by Neil Catchell, and it aims to serve and protect the Constitution through acting through the law. It is a nonpartisan group, although you might expect that there are more current threats from the administration than from other members of the political spectrum. It was founded in 2017, and some of its important work has included preventing more of the scenes that occurred in Charlottesville by acting through state and local laws so that we didn't see a repeat of those events. It's also, ICAP is also working on behalf of the House of Representatives to retrieve material from the Mueller case, a case that is now in front of the Supreme Court. And finally, acting very widely on criminal justice reform. The origins of this call is because I am not a lawyer. And I had some questions arising from my own thoughts on the election, what might happen, what the scenarios might be, how this all might play out. And so I called Josh and I asked him what his opinions were and what his answers to my questions were. And as always, Josh gave me incredibly informative and insightful answers. And so I thought that might be interesting to others as you debate and perhaps are concerned over some of these issues around your own kitchen tables. The format for this evening's call is that I'm going to ask Josh and Mary some questions for about 30 to 40 minutes, probably some of the more basic and immediate questions, and then open it up to your questions, some of which we've received in advance, but also feel free to ask questions through the chat function on Zoom, and we'll pick those up, and to the extent we have time, we'll add them to the mix, and of course we will try and finish this call on time because I'm sure you've all got many, many other things going on today. So with that, I will start the questions, and they'll be organized in three topics. Issues pre-election, issues relating to polling day, and issues relating to post-election. So Josh, Mary, let me start by asking you, what's happening with various legal challenges that are going on to voting laws in the various states?
I'm happy to start, and then I hope Mary will join as well. But first, Jonathan, let me thank you for suggesting this, for doing this, but much more so for being just an extraordinary source of support to ICAP, being a board member and really just being a sounding board as we confront all sorts of fun, but sometimes challenging strategic courses of action. And so we are so grateful for all that you do to keep us at ICAP doing what we do. And it's really fun to get to do this with you, and of course, with my partner in crime, Mary. So, people ask, well, will this election get to court? This election, in a sense, it's in court. There are dozens of cases about the election, and if depending how many elections you talk about, hundreds of cases about the elections already percolating through courts, and they're generally about how one can vote, and in particular, how one can vote amidst these very, very strange circumstances of a pandemic. So you see states to some degree, and some states trying to accommodate that in different ways. More drop boxes, no witness requirement if you want to do a mail-in ballot. You don't need to find some other person, exactly the sort of thing we're trying to encourage people not to do right now, and stand near them and get their signature. Questions of counting and how to deal with what is anticipated to be, really certain to be, an unprecedented volume of mail-in ballots, and what it means to ensure that the ones that are sent are counted, and when that counting can begin and end. Those are the sort of questions already in the courts. Courts are providing answers, and overall, we should know the rules of the road, at least in the various states, because this is very much a state-by-state set of issues as we get closer to Election Day. But Mary, do you want to say a bit more on that as well?
I think you covered it really well. I would just say that, these things are usually first going up to their state Supreme Courts. And then, as we've already seen, oftentimes whichever party is the loser in the state Supreme Court is petitioning the US Supreme Court. And of course, we just last week saw that the US Supreme Court, by a divided vote 4-4, let stand a Pennsylvania Supreme Court decision, which was an important decision, which allowed for counting ballots that come in after Election Day for 3 days. And that's one of the key issues in many states is, particularly given delays with the Postal Service and different changes that the Postal Service has implemented, there's concerns that people even who vote well or who mail their ballots even well in advance of Election Day might not have their ballots counted if they come in late. So that and other issues that Josh has mentioned are very much percolating through the courts. I think one of the challenges is that the rules do keep shifting, because as one court decides one thing, sometimes it gets appealed and sometimes it gets reversed. And so voters get a little bit caught in between, not knowing what they can do. And the safest thing, frankly, to make sure your vote is counted is to go do it in person. But that might not be the safest thing for everyone, particularly those who are, particularly immune to coronavirus.
Is there in the key swing states, I'm thinking of the Pennsylvanias and Nevadas and Wisconsins, is there a pattern forming that's either sort of pro vote or pro suppression, if I can frame it that way?
Again, I'll take a first stab. So I think we see in some of these states an effort to be, I would call it pro voting, right? The very issue that went up from the Pennsylvania Supreme Court that Mary mentioned, that the Supreme Court, the US Supreme Court, did not halt because of a equally divided 4-4 vote, I would describe as pro voting and pro counting, right? It said that ballots that had been received within 3 days of Election Day would be presumed to have been mailed on time and therefore counted. And the court below didn't just choose that approach willy-nilly. It reflected a sense that there may well be delays in mail this year. In fact, that's a sense that's been documented and led to litigation of its own, including some court orders about restoring some of the faster mail processing in order to help get ballots to where they need to be counted in time. So you do see that. You see in Nevada this effort to facilitate voting. You also see in some states, especially states where both the governor and the legislature are in Republican hands, frankly, an approach that I think can only fairly be described as anti-voting and anti-accommodating voting and vote counting. And despite there being a pandemic, a sense of fewer drop boxes and less accommodation for those who it might not make sense to get a witness signature or to even show up in person this year. And in some ways that makes the 2020 election feel, or at least the pre-election period that you have us focused on right now, Jonathan, about a contest between voting and not voting, which of course should not be the contest. It should be a contest of ideas between candidates. And yet it does feel a bit like a contest about the side pushing voting and the side restricting that, or at least failing to accommodate that right now.
And is there anything left that can be done through the courts between now and recognizing there's only 8 days left, but anything left that can be done proactively to encourage and facilitate more votes being counted?
Well, I think the litigation that's ongoing is important in that regard, although, as I indicated before, it can be very confusing when the rules of the road change sort of midstream, and we are very much in early voting in many, many states right now. Still, particularly when we're talking about this key issue about how long ballots will be counted post-election. I think it's very important to get that litigation, get answers to that in time for November 3rd and beyond, so that states know what they can do. If we're still litigating those issues past Election Day, and we very well may be, but that will then, cause confusion in just the tabulations, right? And that will cause delay in potentially being able to announce a winner. And that has all kinds of downstream ramifications, I think, when it comes to what will be then happening, what will be the state of play on the streets and in the towns and in the cities as we're waiting for that vote. So it's important that courts that do have to address these issues do so quickly. It's also important that as new roadblocks come up, that there are lawyers who are ready to litigate quickly. And we are ICAP is among the groups of lawyers who are prepared for litigation. We've been focusing some of our efforts on possible voter intimidation litigation in response to things that might actually happen outside polling places. And in particular, armed unlawful militia activity that might be intimidating to voters, as well as other types of voter intimidation. So we have brought together a coalition of national law firms to sort of supplement our small team, because we are a small team, who are prepared and ready to seek emergency relief, as soon as we hear of problems like that. We have done a template complaint under Section 11B of the Voting Rights Act to be able to go into federal court very, very quickly and seek emergency relief. And we're also prepared to support other litigation that might be necessary on Election Day and in the days following Election Day. And so as these things arise, there's a lot of lawyers at big law firms doing this that are willing to do this work and support this pro bono. And in fact, there's actually an article in Law 360 today about all the law firms that are stepping up to try to be available should we need to go that route. But it's never, litigation is not quick. It's not nimble. And so, it'd be great if we all are geared up and don't have to, do any of that.
So looking at polling day, and again, apologies for the non-lawyer question, but what does the law say about intimidation at voting places, and what constitutes intimidation? Is that, does somebody have to be verbally addressed? Does somebody have to be physically addressed? Does the person just have to feel intimidated? What really is the bar? And then what's the repercussion if that bar is crossed?
Sure. So federal law prohibits voter intimidation, both as a matter of criminal law and civil law. So that means voter intimidation could be criminally prosecuted by U.S. attorneys' offices, or it could be the basis for a civil lawsuit. And the law I was just mentioning, Section 11B, does not actually require an intent to intimidate. It requires that the action be intimidating. And so that's a useful tool. Every state has some type of voter intimidation or voter interference prohibition. Again, sometimes these are criminal statutes. Sometimes they also allow for a civil cause of action. But what's interesting, and goes directly to your question, Jonathan, is that intimidation itself is usually not defined in these statutes. And sometimes they use other words like menacing, etc. And the other interesting thing is there is not a whole lot of case law under the voter intimidation statutes, which I think is probably for a number of reasons, including the fact that by the time you're litigating on Election Day, being able to get relief in time for it to make a difference can just be difficult to do as a matter just of the temporal logistics of it. Here, of course, because we have this year, so many states engaged in early voting, to the extent that some of this intimidation might be surfacing early, there is an opportunity to use legal actions to prevent it going forward and prevent it on Election Day itself. So some of the things, ICAP put out fact sheets. I can probably hold one up here in front of the screen, fact sheets that we distributed widely across the country that give examples of what voter intimidation could be, which are things obviously like violent behavior and threats of physical confrontations, confronting voters in military-style uniforms or while armed, brandishing firearms, directly challenging a voter's qualifications to vote, following voters to and from the polling places, taking down their license numbers. These are all things that we think are examples of activity that would hold up as being intimidating under law. We've also put out fact sheets for all 50 states describing what a unlawful militia is and explaining how unlawful militias are not protected by the Second Amendment, which we can get into later if folks are interested, and then providing the laws in every single state that ban private paramilitary organizations, private militia organizations. So we think there's a lot of tools available for state and local authorities to prevent voter intimidation, and it's important that they know those tools. That's partly why we've been putting out fact sheets. We've been doing other webinars like this, including with state and local officials, meeting individually with state and local officials for weeks now in order to prepare to prevent voter intimidation.
So Mary, where does the law sit on the balance between the Second Amendment and private militias? You said that they're not allowed, but perhaps you explain why that's the case. It's not intuitively obvious.
Yeah, so many unlawful militias will point to those words well-regulated militia in the Second Amendment, and they'll say, well, that's us. You know, we've got a commander, we train together, we have a hierarchy, we're very coordinated and organized. But well-regulated in the Second Amendment has always historically meant regulated by the state. And the same is the case when well-regulated militia is used in individual state constitutions. So even before the founding, even before our independence, when the colonies were forming, they were concerned about the tyranny of a standing army. They did not want a standing army to infringe on civil liberties. So instead, they decided they would have militias, and they defined that to mean all able-bodied residents between certain ages who were available to be called forth by the governor in defense of the colony. And when called forth, they were armed and trained by the governor. They had no authority on their own to call themselves forth. And that was then baked into the US Constitution and baked into the constitutions of the states. And it remains the case today in all of the states that only the governor can call forth the militia. Now, today, in modern times, we have a state militia in every state, and that's called the National Guard. And those report up through the governor, but they're in certain circumstances can also come to the aid of the United States under congressional authority, congressional, constitutional, and statutory authority. The other provision well, it's the same provision. The other thing that unlawful militias will point to is the Supreme Court's interpretation of the Second Amendment to protect an individual right to bear arms for self-defense. And particularly in an open carry state, like so many states are, unlawful militias will say, well, this again shows that we have a right as individuals to join together, openly carry firearms, and engage in this type of activity. But for all of the gray areas in what the Second Amendment protects, this is actually one area where the Supreme Court has been remarkably clear. As far back as 1886, the US Supreme Court upheld against a constitutional challenge a state statute that exists to this day on the books of 29 states that prohibits bodies of men from gathering together and associating as a military unit or parading or drilling in public with firearms. And the Supreme Court back in 1886 said it was without question, states had to be able to prevent these paramilitary organizations in order to maintain public safety, peace, and good order. And even in 2008, when the US Supreme Court decided for the first time that the Second Amendment protects this individual right to bear arms for self-defense, Justice Scalia, writing for the majority, pointedly contrasted that with paramilitary organizations, reiterating the holding from 1886, saying no one has even argued to the contrary, and that case stands for the principle that the Second Amendment doesn't prevent states from barring paramilitary organizations, and all the states do. They all do because the only lawful militia in the states is a state militia.
So we've all seen some of the incredibly long lines of people waiting to vote, which is both hugely positive, but also somewhat depressing to see people having to wait 11 hours. Are there quote, reasonable limits to how long somebody can wait to vote? Can voting hours be extended in certain states if those reasonable limits are breached? Or is there just a hard cutoff and that's it? Or does it vary state by state? And obviously, people are interested in the key states, not the Californias and North Dakotas of the world.
Yeah, I'm smiling in part because Mary and I were interested in this issue, not just of how long voters in America have to wait, but how much it affects certain communities in certain areas, and much less so certain other communities in other areas. Before there even was a pandemic that meant that early voting got the additional stresses that we see this season. And let's start out by looking at this particular election cycle. Based on estimates of Americans who will vote, 1 in every 3 Americans who will vote this election cycle has already voted. So it's an astonishingly heavy voting to happen. Moreover, the advance voting in 2020 has already exceeded the advance voting in 2016, even though we're 8 days away from Election Day, and presumably that's many, many millions of votes still to go before November 3rd. We're at over 56 million votes cast with 8 days to go. So you're seeing long lines in part because there's been incredible turnout, and that's great. We want to see people voting, no matter for whom they want to vote. That being said, the idea that one has to wait, whether they're early voting, whether they're voting day of, for hours and hours, especially in a pandemic, but also especially for people for whom that means lost hourly wages, for whom that means needing to determine what to do with children and childcare, whether that means lost schooling for themselves, whatever it means, it's not the sign of a healthy and functioning democracy. And we are in this position in part because of a decision of the US Supreme Court, in part because in 2013, the Supreme Court struck down Section 4B, actually, of the Voting Rights Act, the same general act Mary referenced earlier, which was the coverage formula for pre-clearance. In other words, it was the formula that determined which parts of this country had to go either to the US Department of Justice or to a federal court to approve changes like closing polling stations or even moving polling stations, which can have a dramatic effect on who finds it easy to vote, who needs to stand in line to vote, and who doesn't. And so we had looked a couple of years ago into this question of whether one could sustain a challenge to wait times in voting based on the disproportionate effect on vulnerable communities and people of color. It's not case law that's been established, but of course that's part of what we do at ICAP is we break ground. And I think this year has called the issue to everyone's attention and will lead to some data and statistics of exactly the type that we were hungry for, frankly, a number of years ago, which is what you need if you really wanted to get at a very complicated problem, which would have very complicated remedies as to what would need to be ordered if you were to try to address these inequities. But I think this year's voting cycle has made clear that there is a problem, that people who want to vote are being forced to endure hours and hours of waiting in line, again, in the midst of a pandemic of all things, that they shouldn't have to. Now, Jonathan, you did ask, are there ways to adjust? And there are ways to adjust. You're not going to solve all this, certainly in the remaining 8 days. Indeed, it hasn't been solved even in some states that overall seem to be pro-vote rather than anti-vote, to go back to our earlier exchange. But there is an ability to keep at least polls open longer. There is still an ability to adjust to the numbers with poll workers if there's an ability to recruit and train. Your basic question, Jonathan, of is this state by state? The answer is almost always yes for voting related questions in the United States, sometimes for better, sometimes for worse, but there is some ability to keep polls open if these lines indicate that there are people who were there well in advance of closure, and yet who would be denied that fundamental, constitutionally protected right to vote if the polls were to close on them before they got into the front of that line and got their vote cast.
So last sort of polling day question, and then sort of look at some post-election day issues. And this may be a sort of classic sort of Twitter echo chamber question, so feel free to laugh at me. But what happens if Trump declares himself the winner on election day results, but before all the mail-in votes are counted? What is actually then the process by which that gets challenged, and how long would that take if he were to do it?
Well, regardless of what he says, I mean, he doesn't get to actually dictate who wins the election, and he actually doesn't have a role in the counting of the ballots. And I will say, if this is the second time I've been asked this question today, actually, so a lot of people are thinking about this. I do think our media are going to be very careful about how they report on anything like that. Obviously, it would be newsworthy if he's claiming victory and they would mention that he's claiming it. But the news media, the fact-based news media, have been really preparing for this election, preparing for the fact that it's unlikely we will know the winner on election day. It could be several days. It could be even longer if there are litigation challenges. And so I think that the fact-based media at least will be clear that until election results are really reported in more official ways, no one could be declaring victory. Now, that doesn't mean he won't do it, and that doesn't mean it won't have an impact, but both the Constitution, state law, and federal law dictates the way that ballots are tabulated. And remember, when you're casting your ballot, even though you're checking a box for president, vice president, what have you, when it comes to the president, vice president, you're really voting for a slate of electors. And every state has a slate of electors based on the number of representatives and the 2 senators in each state. And all but 2 states go by the winner take all method, so that whoever gets the majority of votes in that state, even if it's a 51 to 49% tally, all of the votes go to the winner. That's every state except Maine and Nebraska. And so then those electors, there are dates by which those electors have to meet. They have to then vote, and they then, presumably vote for the winner of their state. Those ballots then go to the Congress, which meets in joint session on January 6th, which is after the new Congress will be sworn in. They count the ballots, and then assuming there's no weird disputes, that's when officially you have a vote. Now, obviously, we always end up knowing before that who the winner is, and we know that before that because when a state goes a certain way, when there's enough votes that have been tabulated in that state to know whether it's going to go for the Republican candidate or the Democratic candidate, at that point, once you hit 270 electoral votes, the media and others feel comfortable saying the election is going one way or the other. So that's why we always know early, even though technically that counting doesn't take place until the joint session of Congress.
And Jonathan, let me just build just to build on Mary's terrific rundown there. 2 points. One, just to give especially this community of folks who track ICAP's work a sense of how we've played into this. I wholeheartely agree with Mary that I think the media is poised to think about this election cycle as exactly the sequence and the timeline that Mary laid out, and in particular as one in which, because of the number of mail-in ballots to be cast, because states that could prove key, even outcome determinative, like Pennsylvania, have laws that don't let those mail-in ballots get counted until election day, perhaps somewhat regrettably, but that's the law in some, not all, but some states, that there may not be an outcome known, and that's okay. In fact, what would be not okay would be to declare an outcome when in fact your legitimately cast votes haven't been counted. And part of the reason I think there's been a greater public understanding is work that Mary and I have tried to contribute to through this group called the National Task Force on Election Crises. And I remember when Mary and I hosted the first meeting of this group that we worked with some partners at other organizations to pull together in June of 2019 at the Georgetown Law campus. And we thought we had enough problems then. We knew we had a president who might declare victory prematurely. We knew we had foreign actors eager to build on 2016 and inject disinformation into our system. We knew we had cyber vulnerabilities. We actually didn't know we'd have a pandemic. We talked about a pandemic and we said we could leave that possibility aside to focus on the others. We brought it back in 2020 for obvious reasons. But part of what that group has tried to do is get out there to media organizations, to labor unions, to company, to anyone who talks about these issues with some constituency of some magnitude, and help them talk about it in ways that prepare expectations along the lines Mary is suggesting. And so I think there's been a lot of work done to try to orient those voices to take us through that process Mary described in a responsible way.
Okay. So let's assume that there is a case that let's assume this ends up at the Supreme Court, which is, I don't know, a reasonable bet one way or another, depending on how the votes go. How quickly do you think that a case could get in front of the Supreme Court, noting that it took a month for them ultimately to decide in 2000 between Bush and Gore? What do you think will transpire in 2020?
So the Supreme Court doesn't like to move quickly in general. It's a reason that there are turtles all over some of the courtyards, because justice moves slowly sometimes. But they know they need to move fast here. They know that if a case gets there, and it may be worth kind of sharpening the question, because of course it's never the whole of the election. It's something specific. It's a recount in a particular outcome determinative state that went to the Supreme Court in 2000. It needs to be an issue, a legal issue, not Trump just saying, I don't want to see votes counted after Election Day, but a genuine legal issue that meets the thresholds that could be outcome determinative. If that gets to the court, they move quickly. I mean, part of the question in 2000 was whether Florida's recount under Florida state law could continue past a date that this year falls on December 8th, the federal safe harbor by which Congress has pledged to respect any state's resolution of its own electors by rules that it had in place beforehand. And Congress has said, if you can sort that out by the safe harbor date, we in Congress will respect it. So they know that this can't be the normal order of business at the court, which is very methodical, very civilized, very patient. Instead, it needs to move quickly. And the court adjusts to that, meaning things that would normally take months and months can take days.
So I'm going to ask 3 very quick fire questions, because I'd like to really get to the questions from others. But if you were Trump's legal team, and I would heartily hope that you don't take that phone call, but if you were Trump's legal team and the mandate was you wanted to win at all costs, what would you do? You don't want the job.
It depends on what level of ethics I have as the lawyer. You know, there are a lot of sort of nightmare scenarios, many of which Josh and I think both try not to talk about really very much publicly, just because they really are nightmare scenarios. But I mean, just to come from my own background at the Department of Justice, doing criminal investigations, criminal prosecutions for almost 25 years, you know, certainly that process of abusing the criminal system for political purposes is one possibility. And that could be announcing investigations into election fraud and things like that normally would not ever be done publicly. You know, we did see some very public statements about election fraud when 9 ballots were found that had been discarded in Pennsylvania. And 9 ballots, I mean, it's not a good thing to be discarded, but it hardly proves widespread election fraud. And we know from the director of the FBI, Chris Wray, has testified recently on Capitol Hill that there is no evidence of widespread election fraud. And we know empirically from many elections, including in states that have been doing only mail-in balloting for years now, that there's no empirical evidence of widespread election fraud. Yet you can imagine, you know, some co-opting of the Department of Justice to try to potentially announce certain investigations based on what maybe some would argue is a significant predicate. Others might say it's not substantial enough to make announcements like that, that could then throw the whole situation into disarray. There's other types of non-criminal type legal challenges, and maybe Josh wants to talk about those, but I think, you know, one of the nightmare scenarios, again, would be that sort of misuse of the Department of Justice. That's different from Trump's own personal, you know, campaign, I shouldn't say personal, but campaign legal team, but that would be a real, like I say, you know, usurpation of DOJ authority for political purposes.
I'll also take on one thing that has surfaced as a possibility. I think it's an unlikely possibility, but I also think it would lose legally. I mean, these things should lose legally, right? If their efforts essentially to steal the election, even if it's steal it via law, the law should say no. So one that has been floated, that one reporter even cited one source within the Trump world as considering, is this idea of invoking a provision of federal law that nobody had heard of before this cycle, and has jump to notoriety. It's actually just a single sentence, 3 U.S.C. 2, that says if a state legislature deems election day failed, that's the word in the statute, it shall determine a new method of appointing the state's electors. And we all know what this means, right? This means if a natural disaster causes voting not to happen or to happen in such tiny numbers that it's failed, state legislature should come along and probably pick another day where the people of that state can vote on the timeline we've discussed, but pick another day. And yet the idea has been floated that if, in particular, a red state legislature, Republican-controlled state legislature in a state that votes blue doesn't like that and deems it failed because maybe mail-in votes are still being counted longer than they'd like to see, that they will use that as an excuse to invoke that authority, determine a new method of choosing electors by making it a vote of the legislature, and then send off that slate, probably in competition with a competing slate if there's a Democratic governor, as there are in a number of key states, Michigan, Wisconsin, Pennsylvania, North Carolina. And then you set up a Congress, perhaps involving the courts, adjudicating which slate to maintain. Again, we've seen this written as a possibility. I just think it's a loser legally. I don't think a court would for a minute deem election day failed because there are still mail-in ballots that need to be counted. It might be failure if you didn't count those ballots that have been legitimately cast, but not because of that. Similarly, even the Bush v. Gore decision, there are many things a lot of us don't like about it, but it said it would be a real constitutional due process problem if a state were to give its people the right to vote, direct election, as all states now do, and then take it back, which is exactly what the play I've just tried briefly to lay out would do. It also is a problem, I think, under other constitutional provisions and under this Electoral Count Act, a federal statute passed in the late 19th century to try to deal with election disputes. So those are the sorts of things we see people speculating about being attempted, and that, as you can tell, Mary and I and our colleagues are working with other partners to prepare for, should they be attempted, but that I think ultimately there are legal answers to beat back.
Great. Well, I'm going to go now to some of the written questions. Jeffrey Gund asks, how do you rate the percentage probability that this election actually goes to the Supreme Court?
So, bless you, Mary. So I'm going to tweak the question because I sometimes worry that in public discourse, it seems as if the whole election is being handed to the court for resolution. And of course, in 2000, it felt that way. An outcome determinative state had a recount, at least a potential recount. And when the Supreme Court, the US Supreme Court, said no to that recount, we all knew what the result was. But I still think it's worth dwelling on the fact that what goes to the court isn't the election. It's a particular issue, as Mary said before, almost certainly arising, at least initially, under state law, with potential federal law overlay, that then, if it's significant enough, plausible enough, outcome determined enough, makes its way to the Supreme Court. And for two reasons, I actually think the odds of that are low. One is looking backwards. Historically, it hasn't happened very often. It happened in 2000 with Bush versus Gore. And in a sense, some Supreme Court justices were lured into a very strange commission created in 1876 to resolve a disputed presidential election then. They weren't acting as members of the court, but they were acting as justices on this commission. But it really hasn't happened much, and so that makes the odds low. And just looking at the polls right now, it doesn't look like a state is going to be outcome determinative that way. The polls right now are very favorable for one candidate and not terribly good for the other. Polls, of course, have deceived us before. They've also been updated since they deceived us before. But if you look at the history and if you look at the snapshot that we get with 1 out of every 3 ballots already cast, it seems that the odds are low. That being said, if it goes, I also think there are legal frameworks that can be brought to bear on it that should weed out some of the more frivolous legal arguments.
I hope you're right. I'm sure we all do. Paul Lewis asked a question. I'm going to summarize this question. What do you make of the president urging people to go to the polls to, quote, protect the process?
Right. So this was, of course, during the first debate, and he said it other times too. And in that debate, it was particularly troublesome because that's the same context in which he told the Proud Boys, a far right militia extremist group, to stand by. It's the same debate where he refused to denounce civil unrest if he was unsatisfied with the results of the election. And in that same context, urged his supporters to go to the polls and watch very carefully. So poll watching or election observing, I think, are terms that get thrown around a lot inaccurately. Every state has its own statutory scheme by which people can, register and be poll watchers, or in some cases they're called election observers. That actually means you're actually able to go inside the polling place, and the idea is to observe the process, to make sure the process, there's some transparency, and to raise challenges if you think there's something about the process that's not being done according to law. It doesn't mean that anyone who says, I just want to go be a poll watcher because Donald Trump told me to, can just go show up at a polling place and walk in the door and start, harassing people or watching what people are doing. What people can do, of course, is go and be outside the polls. And so one of the concerns that we've had and others have is, what would that look like if people are responding to this call? Almost every single state, maybe every state, has a law that provides for a perimeter around the polling place that they call a no electioneering zone. And in that zone, that means you can't be leafleting, you can't be waving banners or trying to convince people to vote for a particular candidate, things that you could do outside that zone. But even outside that zone, so poll watchers, that's a little different than whether you could just be standing there. You could be standing there, but what you can't be doing is intimidating people. And even outside that zone, the voter intimidation laws still prevent intimidation past the 100 feet or the 150 feet or whatever it is in that particular state. Some states it's as little as 10 feet, others I've seen 200 feet. So even outside that zone, you can't engage in intimidating conduct. So to the extent that some of these voters are going to do some of the things we talked about at the top of this webinar or this meeting, that would still be unlawful even outside that zone. I'd also mention that another confusing thing sometimes I think is this idea of who can challenge a voter's qualifications. These are oftentimes called voter challengers, and states have laws about that too. There is the ability for people to challenge other people's qualifications to vote, and the laws differ state to state. In some states, only certain people can be qualified to do that. In other states, almost anybody can do that. But what they can't do generally is challenge a person directly to their face, because that's very intimidating. What they're supposed to do is report anything that they would see as an anomaly or that they think that would support that somebody is trying to vote who is not qualified. And I should footnote, in most states, you have to have a predicate to do it. You can't just say, I don't like the looks of that person, I'm going to challenge their qualifications. You have to have some reason to believe they're not qualified. That should go to the election official, and the election official can then look into it and determine if it's a valid challenge or not. Last point I'd make about this is voters have a right to cast a ballot, even if they're being challenged. It might be a provisional ballot, but anyone who has been told by an election official their vote is being challenged should not leave without casting that ballot, because they have a right to do so while things are being straightened out. And that's, I think, important for people to know.
So there's a slightly overlapping question from Sheldon Tashman, who asks, why aren't state officials stating their intentions to protect individuals from intimidation and harassment?
Well, more and more of them are, as this has been getting more attention, and particularly as we've heard more and more, not just rumors, but public reporting of even armed groups that think they're going to go down to the polls to protect against fraud. We are seeing a number of attorneys general, including from both parties, who are talking about taking voter intimidation very seriously. We're seeing some states and locals, district attorneys, police chiefs, etc., making public statements. We're seeing unity, and in fact, tomorrow at noon Eastern time, ICAP, myself, as well as other organizations are bringing together a number of law enforcement officials to do a press conference and speak to the public. That's going to include a state attorney general, a mayor, a police chief, and a sheriff, and an election official. And we're going to, speak in unity about the need to protect against voter intimidation. So I think we are starting to see more and more strong statements. We've seen some incidences of intimidation that have been dealt with. We've seen in one case where a poll worker was not acting appropriately, who was fired. We've seen some actions taken against police that haven't been acting appropriately. So this is very front of mind. It's unfortunate that it has to be, but it's very front of mind this year. And I do, not that every jurisdiction will be as committed to this as others, but I do think a lot of officials are coming out and being strong on this.
Can I just build on that important point from Mary, which is just broadening it slightly. We're all appalled, at least I think the three of us are appalled by some of the rhetoric we see coming out from Donald Trump and even from those around him, right? It's his attorney general who is echoing claims, baseless claims about mail-in voter fraud. And despite being asked by Congress, what basis do you have for that? And saying he essentially had none. But in contrast to that is what's happening at the state and local level. Not everywhere, but in many places. People who take seriously their role in a system that, as I said before, for better or for worse, is astonishingly decentralized, at least in many aspects, for what are ultimately, of course, elections for federal offices, president and vice president, among others. And people who are committing themselves to dealing with threats of violence, the way Mary was just talking about, folks who were committed to increasing greater access to mail-in ballots, to accommodating those with health needs. You see people for whom voter turnout itself, not for whom they vote, but the fact of voting has become a source of pride. And it really should be. That's what we want an election official. We want them to be excited when people vote, not for whom those people vote. And so given how gloomy the news can be, given how disturbing some of these scenarios are that we are talking about and that we and our colleagues at ICAP are spending time preparing for, because you prepare for it, makes it more likely it won't unfold. But I do think it's worth injecting that note that especially at the state and local level, people are stepping up in different ways, not always evenly, but they are stepping up and they are seeking out our help to inform those efforts to protect the vote.
So the last question from the group, and then I'll go to chat. I'm going to try and get through as many questions as possible, but quickly, Libby McInerney asks, within states, who are the most critical partners for anti-militia work?
Sorry about that, I muted myself. I think it's really everybody. So obviously attorneys general, district attorneys, law enforcement, election officials, mayors all need to be on the same page. So we're encouraging, and when I say ICAP is working with a number of different voter protection organizations, law enforcement organizations, civil rights and civil liberties organizations. We've talked to the U.S. Conference of Mayors, the major city police chiefs, the National Sheriff's Association, on and on and on, about the importance of in each local jurisdiction, sitting down together, creating basically, a command center of how they're going to work together in response to any types of intimidation that might occur. Don't wait till election day. Who is going to call who and how they're going to respond to this. Do that in advance. That's very important. But I also think it's equally important for voters to understand their rights and be empowered. And that's why we've done our fact sheets. And I think by seeing this overwhelming voter turnout that we've seen over the last several days in early voting states shows that people are committed and they feel strongly that they will make their votes heard, their voices heard. And in fact, I think the best antidote, frankly, to intimidation is to come out in those type of massive numbers. And the other thing I'd say is that I think it's critical for everyone across the spectrum, elected, non-elected, community leaders, religious leaders, rock stars, country music stars, professional athletes, right, to be very united that, we choose our elected officials through ideas and policies with which we, the majority agrees, and not through intimidation and violence and gunfire, and denounce any political violence, not only coming into election day, but post-election day. I mean, I don't, as much as these issues about potential political violence are getting highlighted right now. And I think it's important because people need to understand what the law is. They need to understand this isn't protected by the Second Amendment. But I also think the vast majority of Americans, the vast majority, do not want to see us be a failed democracy. They don't want to see violence on the streets. They certainly don't want to see this civil war that some of the more extremist unlawful militias are talking about. And we just need to stand firm on that. So I think everyone is a partner in this to get through this election safely and with, legitimacy so that we can move forward.
Okay, so I'm going to go to some questions in the chat. So Taylor Barrett asks, in a state like North Carolina that does both early voting and mail-in voting, is there a difference in when votes are counted from early voting versus mail-in voting?
So I will confess that I don't know the precise law in that state, but the answer is in some states, yes. States differ in how much they permit votes to be counted, whether they're received by mail and to some extent whether they're cast early, how much they permit those to be counted before Election Day, usually meaning the close of the polls on Election Day. Frankly, among a whole host of things that I would love to see reformed, or I think it's just a fair word to say updated about how we vote in this country, that would seem among them, because part of the stress on our system, part of the reason there may be uncertainty for a few days about who has prevailed is this fact. Now, some states don't have this problem, and so some very large states with many representatives in the Electoral College, we will know quite quickly because the counting can begin. But in some states, and again, I don't know it state by state, we won't. And Pennsylvania is perhaps the most notable of this because they don't allow it ahead of time. And it seems from some polls like it could well be outcome determinative. So if you're keeping a list, I think we're all keeping lists, at least implicitly, of things we'd like to see, it would again have to be state by state, but see improved and updated as we have future elections. Getting those votes that are cast ahead of time counted ahead of time would seem a pretty low-hanging fruit.
Okay, let's see if we can go through a few super quick. Bob Mann asks, is there any provision under federal law to extend the timeline for voting if, for example, a voter is prohibited from voting by polling place violence, or if votes cast at a polling place are destroyed through sabotage, as was seen recently in Boston by a vote collection box being set on fire?
Do you want to go ahead?
Well, there are, start with the states, right? Because it's really the states that govern. Again, I realize we're talking about federal office and it's sort of disorienting to keep pointing back to state law, but it's states that determine what happens generally in those sorts of scenarios. And of course, that person who's voting, if they're denied that right to vote, they are almost certainly, depending on the state, but almost certainly casting votes for state and probably local city office that same day. So it's a mixed ballot, right? It's not that they're doing these separately. And in general, those are governed on a state by state basis. Now, I just want to emphasize something Mary said before, which is I realize parts of those questions a person can't control, but to the extent a person is being told that they're not allowed to vote and believes it wrong, casting that provisional ballot, and in some states asking, when is my hearing on this? Because in some states you have either an opportunity or even an entitlement, if you want, to show up at the adjudication, the hearing that resolves whether you should or shouldn't have been allowed to vote in the first place. It's worth doing. Now, if you're barred to the point of threats of violence by a private militia group, I realize you're not getting that opportunity, but in that case, you get on the phone to law enforcement right away. And Mary, do you want to say more on that?
Well, I was going to say another option also is, and this does happen in many elections, there litigation to keep the polls open longer. And each state has the ability to do it, and then through litigation, it could be ordered by a court if there's a reason, if there's a valid reason for challenge. I'd also go back to, we keep saying up to the states, and that's by Constitution. It's the U.S. Constitution really does delegate a whole lot of this sort of authority for elections to the states, and that's why so much ends up being variable state to state, as we've been discussing.
So Josh, here's one for you, and it's a forward-looking one. But Richard Ambrose asks, in the event of a Biden victory in November, which of ICAP's priority constitutional protection initiatives would become most viable?
I love that question for various reasons. So let me start on just a gloomy note, which is I think this issue that we've spent some time talking about today and that we've spent a lot of time working on with our colleagues since 2017, this private militia issue, is not going away. If anything, I have some concern, I think Mary shares it, that a Biden victory could make it, at least in the near term, worse in some ways, given groups' response and the language that might come out of Donald Trump if he loses. And so I never want to be too quick to think that some of the issues that have been high priority for us in the past are somehow going to be resolved. But I do think that going forward, the idea of criminal justice reform is one where we can make a lot of progress. And that's partly because we're already making progress. We have cases around the country, filing amicus briefs around the country. It's partly because I would love to see a federal Justice Department that sometimes files helpful briefs. That's what they used to do under previous administrations. Now they file briefs that are on the opposite side sometimes, or they sit it out completely. But to have the federal Department of Justice sticking up for some of the issues we care about, I think could be helpful. And I think it's partly because there's a growing political consensus around some of these issues. You just shouldn't criminalize poverty through cash bail or unlawful fines and fees. So I would love to see us accelerate what I already feel like is progress in that area. Mary, what do you think?
I just want to add as well, our litigation, I know we've never done an empirical breakdown, but even though some of the high publicity cases are against the Trump administration, we do have plenty of litigation going on that doesn't involve the US government at all. Criminal justice reform is a major one of those, but also the protection of immigrants' rights, because even though part of our litigation has been directed at the federal government on that, we've also been involved in state litigation where people want to enforce anti-sanctuary cities and anti-welcoming city policies in ways that are very harmful to immigrants and harmful to public safety, I might add. We also have ongoing efforts to improve court transparency, which again are mostly focused at state courts that are just unfortunately too often closed when it comes to really, letting the public have access, particularly in criminal cases. So there's quite a lot of work still to do that actually be kind of nice and a breath of fresh air to be able to focus on some of that work to improve things across the states in so many areas if we didn't have to focus quite so much about what new horrible thing the federal government is doing.
Well, hopefully it'll come to an end relatively soon and you both will get some sleep. Thank you for answering all those questions on the election. Just for everybody on the call, thank you for joining us. And this has been recorded and will be on Georgetown Law's YouTube page. So if you have insomnia and you need to see it again, that is your opportunity. But if you'd like to share it, please do. And finally, as we wrap up, I promised that we would finish on time. But Josh, just quickly, how does ICAP manage all this, and how can folks on this call and their friends and networks help with the effort?
Well, I appreciate the question. I appreciate all of your support to ICAP, Jonathan. And the answer to that question is through a lot of support, including from folks who've been nice enough to join today. And I'm going to drop into chat a link there, but we at ICAP entirely sustain our own salaries, our own filing fees, our own investigations. Used to involve more travel than it does right now, but we look forward to when we can travel and do on-the-ground investigations again. Right now, we're taking depositions via Zoom. We're arguing cases via Zoom. It has all continued in this pandemic world. And so we support our team of 10 full-time, 9 lawyers and a wonderful paralegal administrative assistant. We support that all through donations. We get some support from grants, but we get much of our support from private individuals who share our concern about constitutional protections eroding and diminishing, and have been kind enough to support us in doing everything we can through litigation and otherwise to defend constitutional rights and values. And so for those who've been kind enough to join today, we always welcome that sort of support. The link is in the chat, or we can provide it separately, of course. And we're always grateful to those who let us keep doing what we're doing, because it's an honor to get to do this work, truly.
Well, thanks to you both. Thanks for your time. And it's amazing what you accomplished with only 10 people. I always refer to ICAP as the Navy SEALs of the law. And you are a very small group, but accomplishing very much. Thank you for the insights. Thank you for your hard work. And with that, we'll let you all go back to your days and evening, and talk with you soon.
Thank you. Thank you,
Thanks,
John.
everybody. Thanks, John.
Thanks. Take care.